in the matter of Rubery and Ministry of Defence.
Yes, Mr. Milson.
Yes, my lady, my lords. I appear on behalf of the claimant with the, and I'm grateful for the support of the Equality and Human Rights Commission, who I should mention. Appearing for the respondent, I'll refer to the parties as they were below, Mr. Cooper, King's Counsel, and Mr. Chegwin. The court also has the benefit of submissions from the intervener, the Service Complaints Ombudsman Service. More on those later. That's at tab 20. I'm sure the court doesn't need me to say that they shouldn't carry any less weight, simply because they are written only, not least because if the EAT's decision stands, it's clear that SCOAF will be expected to take on a role her office has neither the expertise nor the jurisdiction to fulfill on her case. The issue before the court is a short one, potentially wider implications, and I set it out in the notice of appeal in the paragraph 1, page 15 of the core bundle.
Yes,
Save with the
crossing out
save with the strike through and retain the EU law. Yep. Although I will come to the significance of the unchallenged findings on equivalence and effectiveness in due course. On proper construction of section 121, as informed by convention rights, are service personnel barred from pursuing claims under the Equality Act where the contravention arises in the treatment of a service complaint, and at the time of the Equality Act contravention, the complainant remains in active service. And it was been conceded throughout that that is the literal effect of the wording of 121 read alongside the 2015 regulations. My lady, my lords, will doubtless have seen these provisions repeatedly in the course of preparation for this hearing, but it is worth turning to them at the earliest opportunity. Section 121, tab 8 of the authorities bundle. Section 120, subsection 1 does not apply to a complainant relating to an act done when the complainant was serving as a member of the armed forces, unless A, the complainant has made a service complaint about the matter, and B, the complaint has not been withdrawn. And the withdrawal provisions follow subsection 2 onwards. The effect of that is to be read alongside the 2015 miscellaneous regulations, or the 2015 regulations as I will call them. Tab 12.
Well, you say that, Mr. Milson, but why?
Well, the simple point, my lady, is this. It's accepted by the respondent's positive case is that it's statutorily, the claimant is statutorily incapable of doing that which sets as a procedural bar under subsection 1211.
But not as a result of primary legislation.
Indeed.
Not as a result of any primary legislation or secondary legislation that's referred to in the Equality Act. Because one of the things that's missing from the bundle is the definition of service complaint in section, I think it's section 1418 of the Equality Act.
I thought that wasn't there.
Is it? Well, if it is there and I've missed it, I apologise, but I couldn't see it.
Well, the Act takes us back to the definition under section 340 of the Armed Forces Act 2006.
But
we have got that.
Yeah, it only refers to, from recollection, it only refers to subsections 1 and 2 of the 2006 Act. It doesn't refer to subsections 3 and 4.
No.
Well, is that significant potentially?
Yes, it's 116. Yes, we have page 116, which inserts. So this is the 2015 regulations, which amended the Equality Act. In section 141 for subsection 8, substitute service complaint means a complaint made under section 341A or 2 of the Armed Forces Act.
Yeah.
This has been an area of piecemeal change rather than a consolidated picture. And the relevance of that when it comes to Section 3 obligation, my submission is of some importance. The position of SCOAF, the employment judge at first instance, and indeed the claimant, is that there is nothing to suggest that there was a conscious intention to exclude the jurisdiction of the Employment Tribunal when passing the 2015 regulations. And indeed, the explanatory notes to those regulations, which carry some favour with the EAT, are themselves ambiguous. They refer to the availability of alternative remedies as a basis for excluding the jurisdiction of service complaints when it comes to complaints about complaints, as it were. And it may well be that the available remedies that those notes had in mind encompassed availability of the ET. Certainly there's nothing in either the 2015 regulations or the accompanying notes.
But did we get any help from the regulations that I think preceded the... I mean, I had a quick look at the regulations in the bundle of authorities. Am I right in thinking that there was a previous set of regulations in 2007 which preceded the 2015 regulations?
Yes.
Well, they seem, at first glance, to have a rather different effect from the effect of the 2015 regs.
In what sense, my lady?
Well, again, I've only read them relatively.
We see that tab 6, is that
Tab
those?
6, yeah. It may be that I've misread them. But Regulation 9, which somebody has sidelined, says a service complaint panel shall include one independent member in any case in which various things,
yes,
various allegations, including allegation of discrimination. And then Schedule 1 contains a list of exclusions.
Yes.
Subject to paragraph 2, the matter is within this schedule if blah 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 blah. And then regulation 2, which has also been sidelined, nothing in paragraph 1 shall prevent a person making a service complaint about anything referred to in regulation 9(1)(a) to D, where he alleges this is occurred in connection with a matter specified in paragraph 1, which suggests that, again, this is a quick reading, that the exclusions were not intended by the draft of the regs to include allegations of discrimination. Now, the structure of the 2015 regulations is different. So why?
Well, my submission on that is this. You have a whole suite of regulations in 2015 which include, importantly, the conferral of additional rights and powers to SCOAF. Now, one hypothesis is that the scope of service complaints was novated to the jurisdiction and expertise of SCOAF. But that is a different question to the one of the Parliament, or indeed the Secretary of State by way of subordinate legislation, thereby intend to oust the jurisdiction of the tribunal. We say not.
Shall we try and focus on the 2015 regime? seems to me that it might be possible to get some elucidation from the 2007 regime, but it's not in the forefront of your skeleton argument,
no,
nor Mr. Cooper's and Mr. Chegg-Williams, and we've got enough to cope.
Yes.
Several thousand pages of authorities.
Some of which you may even be referred to, my lord. But
Quite.
can I just complete the planks of the legislation and regulations?
Yes.
I'll be focusing upon the 2015 regs, Reg 3, page 143, tab 12.
Speaking for myself, I've got no tabs, so if
In
you
which case I'll just focus on page,
focus on
page 143, in
numbers.
which case I'm grateful. Does that apply with the core and supplemental bundle as well? No.
The supplemental, the core and supplemental bundles in hard copy version, which I'm using, it has some sort of strategic tabs like service complaint materials, but
Right.
not
I'll use page numbers in which.
And my
And
lord
that's
on my right is digital, so
Yes.
he probably hasn't got tabs.
Yes.
either.
No, I have a tremendous number of tabs, so I'm happy.
Oh, right, excellent. Right, yes.
In any event, page 143 of the authorities bundle are the excluded matters, Reg 2 or Sub-Reg 2. Decision made under the regulations made for the purpose of Section 340B4A admissibility, decision on the service complaint, determination of an appeal, and Sub-Reg E, alleged maladministration in connection with the handling of his or her service complaint. I'll make this point now, if I may. Whilst 3.2e consigns the excluded matter to maladministration of the individual's own service complaint, there is no such qualifier to admissibility decision at first by the decision body or determination of an appeal. Let me spell that out. Another individual affected by a service complaint as to maladministration may bring a service complaint, but cannot bring a service complaint when it comes to admissibility, decision, or determination on appeal. And the effect of that, in my submission on the respondent's case, it's not just complainants that are excluded from presenting a service complaint as to those questions of admissibility, decision, or determination. It's anyone else who might be affected at those stages as well.
So,
Well, the knock-on effect of that on the respondent's case is that other individuals who may experience discrimination as to admissibility, decision, or determination, who are not themselves bringing the service complaint, are nonetheless also precluded from making an SC and in turn pursuing a claim before the Employment Tribunal. In other words, the exclusion of Section 121 is broader than those who simply bring service complaints in the first instance. But the relevance of that when it comes to the question of proportionality, I'll come to in due course.
You say the exclusion of Section 121, but that's in a way that's a side wind, isn't it? That's not the apparent intention of the exclusion regulations.
No.
Yeah.
No, the claimant's case is that there is a legitimate purpose to the 2015 regulations, or at least a purpose that isn't disputed, which is to prevent parasitic service complaints. The decision body, the appeal body have had an opportunity to make amends. They don't seek a further opportunity, but that's a different purpose to the exclusion or ouster of the Employment Tribunal.
I find this all quite difficult to conceptualise. It's clear from the primary statute that a serving member of the forces can complain of substantive discrimination against her, can make a service complaint, and as soon as it's registered or whatever they do, she can lodge a claim with an ET.
Yes.
And I understand from somebody's skeleton argument, the usual practice is for the ET to wait and see what happens with the service complaint, but they don't have to.
And whether that's usual practice is not accepted by the claimant.
Oh, well, a claimant might say, I think the service complaint system is a sham. I've lodged a complaint because I have to, but actually I want my ET case heard.
Yes.
With witnesses and all the trimmings and so on.
Yes.
Why then should it have been Parliament's intention that there should be a separate way of a route of complaint to the Employment Tribunal, that the service complaint, either the service complaint system as a whole is unsatisfactory, or the service complaint body did not perform satisfactorily and inflicted discrimination on me?
In the same way as to, given that the unchallenged findings of the ET and the EAT, that there is a proper analogy to be drawn between the worker presenting a grievance and the armed forces personnel. Discrimination can transpire in the course of a grievance process. Indeed, there may be no discrimination prior to the pursuit of the or the involvement of the service complaint procedure. Discrimination may arise for the first time in the course of that process itself. The claimant understands that whether by accident or design, there is increased use of oral hearings following this litigation.
Mm-hmm.
Let's say the decision body subjects the complainant or anybody else to sexual harassment during the course of that oral hearing. There may have been no prior discrimination prior to the service complaint process at all. And yet on the respondent's case, that would be outside the jurisdiction of the tribunal. Similarly, to complete the picture, the service complaint procedure may be the last roll of the dice of somebody who is dissatisfied or aggrieved and becomes the armed forces equivalent of the final straw, leading to an application for voluntary discharge. On the respondent's case, regardless of the consequences of that service complaint process and the post-termination losses that may follow, the tribunal has no jurisdiction, which is why I characterise it in my notice and submissions, that this is an ouster, however egregious the contravention and however consequential its effect.
What is the role of judicial review in this?
Judicial review is available in respect of any agreed.
Let's suppose you have what you've described as, I can see how it might arise, an egregious and consequential event arising not from the original complaint, but from the treatment of the original complaint. If it was egregious and consequential, could it not be dealt with by judicial review?
Well, we know from the Supreme Court in Michelag that the primary determiner of complaints of discrimination is to be regarded as the Employment Tribunal.
Yes, but I appreciate there may be, but we're not concerned here about better.
Well, we are when it comes to Article 14, my lord.
Yeah, but appreciate those points, but I'm just trying to understand whether the consequence of your submission is you are or not left without a remedy.
Yes.
I mean, that if it had been a faulty process leading to an egregious outcome, then could they not be told to go away and do it properly?
Yes, I mean, there is the availability of judicial review. In just the same way there is as regards the former personnel who may choose to invoke the service complaint procedure, who has access to service complaint regime, SCOAF, and judicial review. But we know, because the tribunal, the findings of the ET and EAT are unchallenged in this regard, that the availability of judicial review does not satisfy the problem of equivalence when it comes to EU law. And we would say that the determinations on equivalence can and should be read across to less favourable treatment for the purposes of Article 14. I mentioned Michelag, my lord, if I take you to it.
Yes.
It's page 1062. And the meat of the point is paragraphs 15 onwards, page 1067. And if I could ask the court to read paragraphs 15, 16, 19 and 22 over to 1068. So, my lord, I accept that it's not the claimant's case that there is no remedy whatsoever. But we're obviously mindful of what the Supreme Court said as to the quality of the remedy as compared to the Employment Tribunal. Indeed, this court, in the case of Appellant, held that an Equality Act complaint determined in the county court, as opposed to the Employment Tribunal, reached the principle of equivalence. And so, in comparing judicial review with access to the specialist tribunal where costs don't follow the event, etc., of the Employment Tribunal, Lord Kerr's observations and indeed the ratio of Michelag is opposite. So in the respondent's case, the effect of the regulations when read alongside the Act is to impose a procedural bar which, in the words of its own grounds of resistance, for the court's note paragraph 12, page 144, the claimant was, quote, statutorily incapable of satisfying. not being said by the respondent that the claimant ought to have walked into a closed door and presented a service complaint. It's accepted she couldn't do it. But only where the contravention takes place during the currency of service. The Employment Tribunal would, on the respondent's case, have jurisdiction over the exact same act if it happened to take place hours, days or weeks after discharge from military service. Irrespective of the service status of those who are said to have been implicated or perpetrated the act of discrimination. The short question with which I open my notice then leads to sub-questions which correspond to the two grounds of appeal. Is that reading compatible with convention rights? And I'm grateful to the narrowing of the issues, which is now clear from my learned friend's submissions. It's accepted that we're within the ambit of Article 6. It's accepted that there are two valid other statuses, service personnel as compared to civilian workers, or active as compared to former service personnel. My learned friend also accepts that whilst Article 6 on a freestanding basis was not advanced in first instance, that was the kernel of the notice of appeal to this court, and does not object to it, subject to what I have to say orally. The respondent also accepts that there is less favourable treatment for the purposes of Article 14, or at least doesn't dispute it, and so we're focused upon justification. And the second question is, if there is an unjustified contravention, can Section 121 be construed compatibly in accordance with the sweeping interpretative obligations under Section 3? In his decision sent to the parties on the 14th of November 2022, Employment Judge Hanning and my submission provided a model judgment, concluding that there was an incompatibility and that it could be remedied in accordance with Section 3. The EAT concluded that whilst there was prima facie Article 14 discrimination, the appeal of the MOD was nonetheless upheld on grounds of justification and Section 3. In a nutshell, the claimant says this: the tribunal was right and the EAT was correspondingly wrong on both of those questions of law, contravention and interpretative obligation. There's a moot question following the Supreme Court's case of Schvidler as to whether this court is undertaking a review or refreshery assessment exercise. We say the latter, but in any event, if the ET was right, the EAT was wrong to take the alternative course. Barring serving service personnel, access to the tribunal is an unjustified contravention both of Article 6 on a standalone basis and Article 14. The EAT failed to grasp the full sweep of the interpretative obligation, and the EAT in this court has a suite of options open to it to remedy that contravention where drafting is not of the essence. The simplest way of doing it is that perhaps suggested at first instance, if I can take you to it, it's the ET's decision for those who have tabs, tab 9, and it's page 133, paragraph 89. The simplest way to achieve it in the eyes of E.J. Hanning would be to read in the words where the claimant is entitled to do so at the start of section 1211A. That may have a broader effect, so the claimant's suggestion was adopted. You see the proposal there. There's an alternative approach suggested by SCOAF at paragraph 23 and 24 of those submissions, page 258. That would remedy the situation in the of the claimant. Contrary to the respondent's case, the claimant did more than enough to satisfy such a requirement. But because of the issue of those who are barred by way of Regulation 3(2) from presenting service complaints on admissibility, decision or determination of appeal, may not provide the full answer. But in any event, none of those options exceed the parameters of Section 3 or involve the court doing anything other than that which Parliament asked it to do by enacting the Human Rights Act, namely interpreting legislation in a manner which conforms to the with Convention. And if you're not with me on all of that, the claimant seeks a declaration of incompatibility, which is, as I see it, or as I understand the respondent's position, not opposed.
And I think it's accepted, isn't it? Even if paragraph 89 of the ET judgment was constitutionally above the employment judge's pay grade, it doesn't really matter now because we can put that right.
Before I turn to the substance of my submissions, given the public nature of these proceedings and their potential reach via live streaming, I hope the court doesn't mind if I say this. On New Year's Eve of 2024, Nick Hanning passed away far too young at the age of 60.
Oh, I'm sorry to hear it.
Following a long period of illness. Following qualification with the Chartered Institute of Legal Executives, his was a career of first. The first Silex partner in a solicitor's practice, the first Silex employment judge, and at the end of last year, despite his illness, the first legal executive to be appointed as a recorder. In addition to these milestones, his career was marked by an unshakable commitment to the importance of pro bono work and access to justice. His obituary in the Law Society Gazette described him as the nicest man in the law. None of the advocates, as far as I'm aware, can profess to know him in any sense intimately, but regardless of the outcome of this appeal, I'm sure that I also speak for Mr. Chegwardin when I say that we saw much to corroborate that assessment at first instance. His commitment to justice and the rule of law will endure. Turning then to the structure of my submissions, I want to deal with certain features of the factual background, then the legislative scheme, and then the grounds of appeal in reverse order to my notice, breach followed by interpretive obligation rather than the other way around.
Right.
Might be thought putting the cart before the horse in my submissions. Background. The context of these claims are set out at paragraphs 26 to 34 of my skeleton, and there's little with which the claimant quibbles from paragraphs 9 to 21 of the EAT judgment. The issue before this court is one of jurisdiction, and so the facts must be taken at their reasonable heights. I can take those relatively briefly. The claimant was engaged by the RAF for some 30 years and alleges adverse treatment as a woman, or particularly whilst undergoing IVF treatment. The timescales for her ultimate service complaint are by no means atypical. Service complaint presented on the 27th of September 2018. Service complaint dismissed 30th of October 2020. And so, as to my Lord Justice Bean's point, plenty of reasons why a claimant would not want to sit and wait around for the service complaint procedure to resolve. Appeal dismissed 1st of December 2020, appeal presented 1st of December 2020, outcome of that appeal 28th of April 2021. Throughout that process, the claimant repeatedly asked for an oral hearing and alleged by way of the appeal that the approach to her complaints had failed to redress an overly masculine culture within the RAF. If I can take you to the supplemental bundle, page 75. Tab 10 if you have it. Challenge to the finding of the DB that comments on mano a mano, ballsy, grow a pair, etc. were not related to gender.
Yes, well, I mean, we'll take this from your skeleton argument. You don't necessarily have to show us the primary document.
Let me deal with it this way, then. If the point that's raised by my learned friends at paragraphs 14 and 60 of their submissions is that the complaints which formed the basis of the ET1, victimisation and indirect discrimination, were not contained either before the appeal process or by way of the SCOAF referral. If that is a point which which engages this court, the claimant would resist it, right that she doesn't invoke the language of sections 19 or section 27 of the Equality Act. But if the EAT held in Edwards, there's no need to. What is clear is that at the appeal and at the SCOAF stage, the claimant did challenge the approach to her complaints, and both as to the rationality of those conclusions and the continued denial of an oral hearing. If that is a point developed further by my learned friend, I'll come back to it by way of reply. The claim before the Employment Tribunal, we have at page 150 of the bundle. Page 163 of the particulars. Decision not to allow an oral hearing, or the practice of not holding oral hearings, is a practice which gives rise to particular disadvantage. That's the indirect discrimination claim, as to which the claimant would note the sentiment shared by the EAT for your note, paragraph 130, page 87, that the failure to hold an oral hearing strays into the area of breaching effectiveness. And then victimisation, as to the reasoning and decision to not uphold the complaint, that the rationale for that being paragraph 25, page 165. The response to that claim, tab 10, the phrase which I've already made mention of, paragraph 12, page 144. Employment Tribunal has no jurisdiction over excluded complaints because a complainant is statutorily incapable of satisfying the requirement in section 121A of the Equality Act. I deal with the conclusions of both ET and EAT at paragraphs 35 to 40 of my submissions, and I'll turn to them in a little bit more detail under each heading of breach and interpretive obligation. Before I do, I wish to set out 8 salient features of the legislative framework and the procedure governing the Equality Act and service complaints. First,
hang on. If you're going to give us a list of 8, they may be in your skeleton, in which case give us the reference. If they're not, then could you go slowly?
I will indeed. some of them will be longer than others, but I will keep to the numbering.
Yes.
First, the Equality Act treated discrimination within the armed forces as discrimination within the field of employment. And if we go to tab 9 of the Authorities Bundle, section 83, subsection 3, page 82. This part applies to service in the armed forces as it applies to employment by a private person. For that purpose, references to terms of employment or to the contract of employment are to be read as including reference to terms of service, and references to associated employers are to be ignored. Parliament did not seek to have a separate category applying to the armed forces. Whilst my learned friend relies upon a case of Anderson at paragraph 38 of his submissions, that's respectfully a relic of an era where there was no right to have access to the ET at all. Second, a service complaint is not a particulars of claim. The complainant is not required to set out with exactitude the basis of the claim. And if I can take you to Edwards, which is tab 60, or page 1706. The EAT considered the question of what level of exactitude is required to comply with the requirement to present a service complaint, and referred to the case of Gu and Zulu, a first instance decision. I hope the correct version of that has made its way.
Not to worry. The changes are any presence or absence of sidelining.
Well, the version that you originally had in the bundle of Gu and Zulu was the first instance merits decision, which I don't think would detain this court very long.
Oh, it was actually the wrong document.
It's the wrong document. The version in the Authorities Bundle is the liability decision of Employment Judge Beatty, which assists this court not a jot.
Right.
The correct version is that which was sent, I hope, yesterday. Decision of Her Honour Judge McNeill sitting in the ET. First instance decision only, but approved by Mr. Justice Williams in Edwards and MOD. And if I could take you to paragraph 33 first, that's page 1716. None of the appellant cases summarised above were concerned with the question of what a service complainant is required to do. That question did arise in the ET case of Zulu and MOD, a decision which was not only not appealed by the self-same respondent, but averred as being correct in the course of Edwards. And the test as to the inclusion or whether the requirement of section 121 is satisfied, we see paragraphs 89 through, it should be sidelined but they're not, 89 through to 92, page 1734 to 5. If I could ask the court to read those paragraphs.
Sorry, just looking at 120 and 121.
Yes, my lord.
To see how they fit, if at all. With anything that we're concerned with here.
Well, it deals with the point that's raised at paragraphs 14 and 60 of my learned friend's submission on claimant's non-compliance, but it also addresses the point that the service claimant need only raise a complaint about the matter defined in broad terms, rather than use the service complaints process as the arbiter of the discrimination claims.
Thank you.
How far would you like us to read?
89 to 92
Right.
suffice it. Point number 3. Once a service complaint has been presented, all the service person must do is not withdraw it, whether actively or impliedly. And to that extent, I agree with my learned friend's submissions, paragraph 42 of their skeleton. 4. When enacting the Equality Act, Parliament deliberately loosened the grip of the service complaints process on the tribunal's jurisdiction. And I'll develop that a little further if I may. If I can take you to tab 2 of the authorities bundle, or page 8, the predecessor provisions as to rates.
Well, Mrs. Justice Hannah Williams has just told us in the passage you asked us to read that under the previous regime, the service complaint had to be determined before the claim was presented to the tribunal.
Well, there's 2 changes of note. First, if I take you to subsection 9, so that's page 9. No complaint to which subsection 8 applies should be presented to an employment tribunal under section 54 unless the complainant has made a service complaint in respect of the act complained of. The language of matter was used by way of the Equality Act, which is broader in scope. And secondly, as my Lord has just observed, there is no longer a requirement to wait for the determination of the Defence Counsel. Indeed, on the face of section 121, there's not even a requirement that the service complaint be first presented, provided by the time the question of jurisdiction sees that there is a valid service complaint that's been presented in time. I mean, I don't need to go that far, but certainly there's no question that the tribunal is enthralled to what's decided through the service complaints process, or is in any sense bound or deferential to the findings that are reached. And so, when looking at the EAT's judgment and the summary of the regime, I think this is perhaps the only substantive point I would respectfully challenge of the EAT's summary. If we go to paragraph 26, the EAT's judgment, that's page 58. reference to a service complaint in section 121 is a reference to a service complaint which has been accepted as valid by the prescribed officer under the service complaint procedure, but a decision by the prescribed officer to refuse to accept what purports to be a service complaint can be challenged by judicial review. In my submission that rather overstates matters. You now have the first instance decision of Gu and Zulu, I hope. I don't ask you necessarily to turn to it at this stage if it's logistically challenging to find it. But if I could ask the court in the course of its deliberations to consider paragraphs 114 through to 118 of that decision, in which the tribunal held that deferring to the admissibility decision of the defence counsel would breach effectiveness and equivalence. That passage of Gu and Zulu was not considered by Edwards to the extent that it is relevant to the determination of this appeal. The claimant asks that it be deemed as right. 5. Former service personnel may also bring a service complaint. Page 94 of the authorities bundle. Section 340A, subreg 2. If a person who ceased to be subject to service law thinks himself or herself wronged in any matter, the person may make a complaint about the matter. And the exemptions under the 2015 regulations draw no distinction between active and former personnel. 6. Only a complainant in a service complaint may make a referral to SCOAF. That seems to be accepted, at least implicitly, by my learned friend, paragraph 27. So to take a hypothetical, which I'll extend in due course, senior military personnel pursue a vexatious service complaint against an entry-level aviator, or sailor, or cadet officer, or soldier. The complaint is deemed admissible, upheld, and the service complaint decision body recommends disciplinary action on the grounds of race, sex, or sexual orientation. The decisions on admissibility and the ultimate decision itself can't be challenged by the black, gay, Muslim, whatever it might be, cadet officer by reason of the 2015 regulations. And nor can that wronged cadet officer pursue an avenue with the Service Complaints Ombudsman. It's judicial review or nothing on the respondent's case.
And no ET jurisdiction either.
Because if you can't present a service complaint, you can't comply with section 121. Now, the maladministration exemption only pertains to the service complaint of the individual. The questions of admissibility, decision, and determination on appeal apply regardless of whether the wronged individual is the original complainant or not. Seven, the claimant intends no disrespect to the SCOAF when this is said, not least because this position is volunteered by SCOAF herself. But there are considerable limits of jurisdiction, expertise, practice, and resources on SCOAF. SCOAF is not a second right of appeal. SCOAF has discretion as to whether to accept a referral and the extent of investigation. She does not conduct public hearings. Her conclusions are not binding, and nor are they determined in a public forum. And the submissions of Mr. Halliday on behalf of SCOAF at paragraphs 7 to 12 are respectfully adopted. SCOAF is not equivalent to the tribunal in practice or principle. And if I can take the court, as indeed the SCOAF submissions invite you to be taken, to Maxwell, decision of this court at tab 38. We'll get to a certain point in preparation when one wishes that soft copy had been the route forward, but we're in bundle 2 for those who have it. And it's Maxwell, page 901. This concerned the Office of the Independent Adjudicator in the education field. But you also have the citations of Mencap, in which Mr. Justice Mitting said that there was a close analogy between the role of an ombudsman and the Office of Independent Adjudicator. Could I ask the court to read paragraph 22? Not 22. It's paragraph 22 and through to 23 first. But by way of introduction, before I do, this was a complaint brought by a student who challenged the failure of the OIA to reach determinations on disability discrimination complaints. So the focus of the judicial review was that the OIA should have reached findings on disability discrimination allegations. And Lord Justice Mummery summarises the features of OIA paragraphs 22 to 23 first. Those are then built on at paras 32 to 36, page 911 to 2. If I could ask the court to read those passages as well.
Yes.
Messrs. Cooper and Shagwidden, in order to remedy the discrimination under Article 14 or the freestanding Article 6 contravention, ask SCOAF to do that, and this court to do the very same functions which this court in Maxwell found it was not entitled to impose on a review procedure which performs very different functions indeed. It is not the role of SCOAF to determine complaints of discrimination. She is not equipped jurisdictionally or by way of practicality to do so. And yet that is the answer of the MOD to the asymmetry that currently exists.
What is the role of SCOAF?
SCOAF,
I mean, I'm asking it rhetorically, of course.
No,
I've read what's said about this, but
of course.
how do you put it? If it's not for SCOAF to do that, what is it instead for SCOAF to do?
Its essential function is to provide oversight of the service complaints procedure akin to any other ombudsman. It's not determining civil rights and obligations. It's reviewing on a discretionary basis.
But I mean, crudely one might put it that SCOAF is there in order to determine complaints about the handling of complaints.
Yes, but not to find whether there was discrimination as defined in the Equality Act in the handling of those complaints. And certainly not to do so in a public forum. There's no suggestion that SCOAF is an Article 6 compliant process, if that were the sole means by which civil rights conferred under the Equality Act were to be determined. And whilst the SCOAF office is to be replaced by way of the Armed Forces Commissioner Act 2025, the jurisdiction and competence of service complaints functions simply transfer under that 2025 Act without modification or amplification. It's no part of the respondent's case that there was an incompatibility, but don't worry, the cavalry are coming by way of a new office. 8, and finally, there are a whole array of scenarios where access to the court is not fettered by the service complaint precondition. And as such, where there is no finality in the SC process. Claims of personal injury, for example. Judicial review. And most critically, the Employment Tribunal, where the Equality Act contravention takes place after service has ended. That's a relevant feature, we say, when it comes to justification and Section 3 obligation. Now, against that backdrop, I turn to the 2 grounds of appeal, addressing breach first. If I can turn to the tribunal's, the ET's decision and the way it went about its task first, because we say, in short, that it's right. Tribunal's judgment, tab 9. Records the concession at paragraph 72, page 131, on ambit for the purposes of A14. Finds at 77 in a decision which is no longer challenged, that there is a relevant analogy between, or material analogy between, active personnel and civilian employee. And then concludes by reference to paragraph 79 that by reference to Michalak, P and Eklund, it's clear that the Employment Tribunal is the appropriate forum for complaints of this nature, and access to SCOAF for judicial review are not. Neither of the latter offers the expertise, independence and remedial powers inherent in the Employment Tribunal. Tribunal then considered the aims that were advanced. Paragraph 81, adequate, but Mr. Tugwardin accepts not absolute finality to the internal SC process and its protection from repeat claims or concurrent external claims. Tribunal accepted that the aims of finality of the internal SC process and protection from repeat claims are legitimate, but the result of the exclusion is more than simply that service personnel cannot make a service complaint. It also bars access to the Employment Tribunal. No evidence that this was the intended aim, nor rightly is it said that this would be a legitimate aim. It's obviously not a proportionate means of achieving the actual stated aim. Barring a claim from the Employment Tribunal, there's a much broader outcome that is needed to achieve finality from the internal SC process. And similar observations are made at paragraph 64 to 65, page 130. By reference to the notes supporting the 2015 regs. I accept that summary, but only up to a point. In my judgment, it's right that the limitation was imposed to provide finality within the SC process. If complaints can be made about the complaints process itself, then in theory there's scope for an infinite number of complaints about the handling of each iteration of the same initial complaint. But that is not the same thing as providing complete finality and deliberately intending to exclude the jurisdiction of the Employment Tribunal. As Mr. Chegwin notes, the handling of the SC could be challenged by SCIF referral or via judicial review. The finality was only within the SC process. I did not understand Mr. Chegwin saying that it went further than that, and see the point on para 66, nothing to suggest deliberate intention to oust it. And as, just finally, the tribunal rightly noted at paragraph 84, in keeping with my Lord Justice Bean's observation, the reference to concurrent external claims being an aim of the 2015 regulations cannot be right. Service personnel may currently make a service complaint and then submit a claim to the ET. There's no requirement to wait for the service complaint to be determined before the ET may be seized of the matter. Nothing in the 2015 regulations changed that, save in respect of complaints about the SC process itself. In a nutshell, insofar as there's a name on the tribunal's findings, it wasn't rationally connected to the discrimination in issue. And in any event, the current regime was disproportionate by reference to that aim. Turning then to the EAT's conclusions. Tab 5 again makes the point at paragraph 64 and 65, which is now no longer disputed, that there is a relevant analogy for the purposes of Article 14 between active and former personnel or between service personnel and the civilian worker. At the top and bottom of page, paragraph 65, top of page 61, I see nothing whatsoever disanalogous in their respective situations. Their situations are otherwise entirely similar. And the aims shifted a little bit, paragraph 68, to prevent repeat complaints, prevent challenges to decisions made in the internal system or by the Ombudsman, and to otherwise exclude complaints where adequate alternative remedies are available. For the first time, whether volunteered by my learned friends or a baton seized by the EAT of its own initiative, I can't quite recall, but reference at paragraph 72, bottom of page 72, to morale and discipline in what is often a closed environment, potentially involving active service, long-running unresolved complaints like festering sores are to be avoided if possible, etc. To spell out the obvious, the example of my cadet officer is not one where there's any issues of repeat complaints at all, because there's no original complaint in the first place by that particular individual. And as the ET rightly pointed out, the finality is by no means absolute, given the ongoing role of SCIF, judicial review, and matters of that nature. perhaps curiously, paragraph 77 of the EAT's decision. The EAT said this, page 74. That a complainant may rely upon the handling of the, this is in summary, rely upon the handling of a service complaint as grounds for aggravating damages, increasing injury to feelings. And then the final sentence there, although the ET will not be able to treat the matters as freestanding complaints, there is a wide power to make recommendations, which could include recommendations about the service complaints procedure, the holding of oral hearings, and the like. And then by reference to adequacy of the service complaints appeal process, adequate does not mean identical. And we say that's an error, at least in the context of Article 14. Also, to spell out what the EAT says on equivalence, paragraph 120 if we start at 116, we see the citations hopefully in a single place of P, Eklund and Michalak, paragraphs 116 to 119. Make the point that the general point of paragraph 120, the general point made forcefully in both, presumably means all three, P, Michalak and Eklund, is that disputes arising in the context of employment, which include the service covenant, are best dealt with by ET, the specialist forum for the resolution of disputes between employer and employer with particular expertise, experience and training in discrimination law. And then goes through paragraphs 124 to 128, the various means or the various features which render the principle of equivalence as having been breached. The absence of a public hearing, the absence of cross-examination, paragraph 124, the discretionary element of both DBAB or DBAB and staff as well, the scope of evidence, the absence of a public hearing as to the conclusion, paragraph 125, the comparative unfavourability of the remedy regime, paragraph 126, the absence of any binding remedy, although in practice those remedies were followed, 127. The absence of independence, paragraph 128. And then the conclusion, 129, that they are not equivalent. The service complaints and SCOAF regimes are less favourable and the differences are quite considerable, nor does the availability of judicial review satisfy the equivalence principle. And then in paragraph 130, a paragraph to which I alluded previously, service complaint, SCOAF appeal process and judicial review cannot be regarded as equivalent to the right to bring complaints under Reg 3.2b. It's therefore not necessary to consider whether it also infringes the principle of effectiveness, which the ET found. But the failure to hold an oral hearing to resolve allegations of the type raised by the claimant in her service complaint arguably stray into the area of making it practically impossible or excessively difficult to exercise the rights conferred by EU law. None of that disputed by the respondent on appeal. And we say, just to flag where I'm going in a few moments, that there is a disconnect, a dissonance between the approach to justification and the sweeping conclusions of the EAT on the extent of unfavourability as to the current status quo. That serves as, those conclusions also serve as the helpful launchpad for what we say on a freestanding breach of Article 6, I've already conceded that freestanding contravention, I think, was alluded to relatively briefly but before the ET, not a freestanding ground of our answer to the MOD's appeal before the EAT is raised in this court, and this is in any event a question of law in which no evidence has been heard previously. The point can be simply made. Parliament conferred the right to bring discrimination claims before the tribunal, but imposed in this sphere, on the respondent's case, a procedural bar which the claimant and others like her are statutorily incapable of performing. And the effect of that is the denial of a fair and public hearing, by way of guarantee for the determination of those rights, by an independent and impartial tribunal with judgment pronounced publicly. The DB and AB process satisfies few of the essential kernels of Article 6. There's no public hearing, there's no independent tribunal. And nor, on Scariff's own case, does Scariff itself. No right for the determination of those claims, or those civil rights and obligations, and again, it's not a public hearing. If I can take you to Duncan, an MOD, tab 39, bundle 2, hard copy, page 914. Decision of Her Honour Judge Eady. In which the service complaint made, no action taken upon it, and so therefore on the tribunal's overturned findings, there was no determination by the defence counsel, and therefore the service complaint was deemed to be withdrawn.
I'm so sorry, I'm behind you. Can you give me the reference?
Sure.
To this?
It's page 914. This was an appeal which was essentially conceded by the MOD, hence the brevity of judgment. But I would ask the court to note the concluding remarks at paragraph 4, page 916. Given that I'm being asked to overturn a ruling by an employment judge, I do not treat this as a mere formality and provide this judgment to explain the reasons for my approval of the consent order. There's essential reasons from paragraph 919, page 919 onwards. There is a balance to be achieved between the statutory aim of enabling the armed forces to determine complaints prior to litigation, and the complainant's right of access to a court or a tribunal within a reasonable time. If paragraph 16, the essential implication of that paragraph in my submission being that the failure of access to the tribunal would breach Article 6, fair and public hearing within a reasonable time by an independent and impartial tribunal. And so therefore the EAT upheld the consent order on the basis that the proper construction, paragraph 17, that section 121 should be read to operate as a jurisdictional bar only where there's a right to make a referral to the defence counsel which is not exercised by the complainant, without which there would be a breach of Article 6.
You don't know what the underlying complaints were?
No. Clearly complaints of discrimination, but we don't know what the complaints of themselves are. But Claimant says that the tenor of that decision, indeed the tenor of the position of the MOD at that time is plainly right. That to deny access to the delegated court, provided the complainant has done all that she or he is expected to do, would breach Article 6. The relevance of that, we say, is that the standard of scrutiny for such a breach is heightened. The test is one of necessity as to the public hearing or denial of public hearing rights. The right of access to an impartial tribunal is unqualified, and absolutely there's no qualified justification to it at all. In any event, the scale of the intrusion into the Article 6 right is an important matter to consider when conducting the proportionality assessment. Turning then to Article 14, in view of the narrowing scope of dispute, it's clear that justification is now the only matter at large. What must be justified is not the service complaint regime at large, but the discrimination. And here the discrimination for Article 14 purposes is the wholesale ouster of the tribunal where and only where the contravention takes place whilst the complainant is still serving. That discrimination falls to be justified on the bank mail-out questions. I can take my lady laws to them, but they are familiar. One would hope. I can refresh the memory as it works. Tab 11, page 951. But in a nutshell, is the objective sufficiently important to justify the limitation of the right? Is the measure rationally connected to the objective? Could a less intrusive measure have been used without unacceptably compromising the achievement of that objective? And then whether balancing the severity of those measures against the importance of the objective, the former outweighs the latter. And there's no suggestion, as I understand it, on the respondent's case, that notwithstanding observations as to the approach to Article 14 in SC and other cases, the bank mallet test doesn't apply to an Article 14 contravention in the same way as it does to any other contravention. It will always be relevant, in my submission, to consider the extent of the intrusion into the substantive convention right. And irrespective of the standard of review to be adopted, or the margin of appreciation, there's no rational connection between the aim and the discrimination. Whatever margin is legally irrelevant in my submission, because there's no rational connection between aim and discrimination. Then the justification defence fails at the first hurdle. There's some dispute between the parties as to the appropriate standard of scrutiny to be adopted if there is a rational connection. I can deal with this, I hope, relatively briefly. Manifestly without reasonable foundation is no longer the test, if it ever were in my submission. So much was accepted by this court in Sullivan and the Isle of Wight. That test, in any event, has no traction in the field of decisions on employment policy. And if I can take you to Gillam, page 1113, bundle 3. Tab 48. Page 1114. Gillam being the case, of course, on the whistleblowing protection afforded to judges, or lack thereof, until the Supreme Court's decision. And to save us coming back to it, could I ask the court to read paragraphs 33 through to 36 in full? In fact, 37 in full.
Yes.
Nothing said in SC was sought to set aside, distinguish, still less overrule any aspect of those essential reasons in Gillam. In fact, try one might to look at Gillam in the long list of cases referred to in SC, and it's simply not there at all. There is no treatment of Gillam at all in SC, which of course is in a very different field of allocation of state resources and welfare. More broadly, any margin of appreciation is not to be overstated. Ascertaining proportionality is quintessentially a matter for a court under exercising its functions under sections 3 and 6 of the HRA. And if I can take you briefly to Schwidler, which we have at page 1837. If I can take you first to page, paragraph 120, page 1865. And then 122 as well. No particular need to bypass 121, but 120 and 122 I'd rely upon in particular. Over to the bottom of 1866.
Yes.
And then when it comes to any margin to be conferred to the decision maker, insofar as there's any conscious decision to affect the discrimination here at all, can I just take you to paragraph 124, that the factors that are relevant to the balancing of rights and interests struck by a public authority will include the importance of the right, the degree of interference, and the extent to which the courts are more or less well placed to adjudicate on grounds of relative institutional expertise and democratic accountability. To state the obvious, what the claimant asks you to determine is whether the denial of access to a court is proportionate. Who best to assess that, respectfully, than a court? Schvidler also deals, as I set out at the outset, with the question of whether the appellate court is conducting a fresh assessment or review. And if I can take you to paragraph 162 briefly, page 1879. Review being, was the decision below wrong, as opposed to fresh assessment of proportionality. 162, the joint judgment of the court. Main factors likely to be relevant to justify the adoption of such an approach: the relevance of the assessment of proportionality across a range of cases, whether in terms of establishing a point of general principle or approach, proper interpretation of legislation or proper development of common law, the nature of the measure in question, since the constitutional responsibility of the senior courts is likely to be engaged in a more acute way in relation to challenges to primary or secondary legislation, or whether the case involves a claim that legislation or proposed legislation is outside competence by reason of incompatibility with convention rights, etc. So we say that, having regard to Schvidler, this is a case where the court can and should approach this as a reassessment rather than review process, but you have my primary submission that whichever way one cuts it, the EC was right and the EAT was wrong to take the alternate course. Finally, on proportionality as a matter of principle, my little friend relies upon the fact that the status in issue, service person or active as opposed to former service person, is not a suspect or core status. Clearly it isn't. But the question of whether a status is core or suspect or more peripheral is by no means the only critical factor when undertaking the proportionality assessment. Can I take you to SC, page 1451? Paragraphs 158 to 159, in particular, if I take to the bottom of page 1450, the intensity of the court scrutiny can be influenced by a wide range of factors, depending on the circumstances of the particular case, as indeed it would be if the court were applying the domestic test of reasonableness. Even where there is no suspect ground by C at 1451, there may be factors which call for a stricter standard of review than what might otherwise be necessary, such as the impact on a measure of a measure on the best interests of children. We say, having regard to the bank ballot test itself, the relevant factors on the standard of review include the importance of the right, the extent of the intrusion, and the constitutional competence or expertise of the court to assess the question of proportionality. To spell out the obvious, in Gillam, being a judge is not as core or suspect a classification as sex or race. But what drove the court was the extent of intrusion into the Article 10 rights and the expertise of the court to assess the proportionality of that intrusion. So that's proportionality in principle. Proportionality in practice, at the permission stage, my Lady Justice Laing noted that at first sight the ET's reasoning on justification is more convincing than that of the EAT. Needless to say, the claimant agrees, and it's not just a question of first sight. The reasoning of the EAT as compared to that of the ET doesn't improve on repeated viewing. Indeed, we say that the defence doesn't get off the first hurdle because there's no legitimate aim rationally connected to defending this discriminatory state of affairs, still less which begins to come close to justifying an exclusion of Article or an infringement of Article 6 itself. And it's telling that the respondent's case has shifted on identifying the aim in issue. We adopt the submissions of SCOAF at paragraphs 13 to 16 of those submissions, that we're operating on shifting sands. Final iteration, avoiding collateral challenge to the service complaints process in the interests of maintaining high morale and discipline. There's many problems with that. There are plenty of spheres of collateral challenge. SCOAF, judicial review. This very same collateral challenges depending on the arbitrariness of whether the Equality Act contravention takes place before or after service is ended. But it raises many more questions than it answers. Why is morale best served by excluding sunlight on discrimination? Again, to go back to the example of the cadet officer, you can't bring a service complaint on admissibility, decision or determination of appeal. Compelled to go through the route of JR. Can't bring the SC, can't bring SCOAF. That individual is not somebody who is in any sense caught within the aim of making repeated complaints, which Mrs. Justice Stacey had in mind in the EAT. There's no prior complaint at all. And of course, if discrimination takes place for the first time in the service complaint arena at all, then it's not the territory of repeated complaints, because one's dealing with something which has happened for the first time in the body of the service complaint regime at large. Given the continued challenges to instill, nurture and encourage diversity in the armed forces, how does consigning that cadet officer to judicial review improve morale? Even if a link to morale could be assumed, why is that link there only for those who remain in active service rather than former personnel, regardless of the status of those who are said to have committed the contravention in the first place? Why is access to the tribunal damaging to morale, but not to the administrative court, SCOAF, or by way of a personal injury claim? And then we have the perplexing position of the EAT, which is that there should be no collateral challenge to the service complaint regime. But you can bring it through the back door before the Employment Tribunal. You can get remedies on the basis of it. You can get recommendations on the basis of it. You just can't bring a freestanding complaint. Why?
Sorry, what do you mean by the back door?
Well, the passage of Mr. Justice Stacey's judgment that I took you to, where it suggested the extent of the discrimination could be ameliorated by reference to the ability to bring or enhance damages.
Can we just look?
Yeah, of course. So it's paragraph.
77.
I'm grateful. Thank you, my lord. Page 74. One can call evidence on the deficiencies of the service complaints process, gain greater damages as a consequence, get recommendations to improve it. But bringing a freestanding claim about it, that's apparently beyond the Rubicon and damages morale. Why?
As you're talking about proportionality in practice here,
Yes.
can you just illustrate how your client is worse off because of the limitation of which you complain in comparison to what we see at 77?
Yes. Her case before the in her pleadings, there's two claims, and they should be read in conjunction. That as a consequence of the way in which her service complaint procedure was handled, she developed depression, became disillusioned with her time in the armed forces.
I'm trying to understand the context, but does that or does that not fall within 77?
If I can just feed through the picture, my lord. She would wish to say that it's affected her career ambition and her approach to her approach to the her trajectory within the RAF. She would also wish to say that there was an opportunity to for her to be vindicated, which could have led to a different outcome. Now, what's meant by paragraph 77? Can she say, I was so disillusioned with the service complaints process that my career path is entirely different? If she can, then why can't she bring a claim about it?
No, but I understand your logic point, but we've been into proportionality in principle. I'm now asking about in practice, and just trying to understand what it is that you say she can't do under the result of the EAT, which she could do if you were right.
Well,
where is she going to come up short?
Difficult to see how she could get a freestanding injury to feelings claim in relation to a claim that she can't bring. So when it comes to the claims of victimisation and indirect discrimination that she wishes to pursue as regards to service complaints, a freestanding personal injury claim or injury to feelings or personal injury claim in relation to those matters, it's unclear how far paragraph 77 goes.
The appeal tribunal appears to have thought, as I read this without experience of these matters, to be saying that she can pretty much bring everything to the table in the complaint that is going to go ahead, which would include the experience of discrimination, victimisation, would include the aggravation of that by the fact that they didn't investigate the complaint properly. It would include the fact that that's led me to be depressed, that's damaged my career. So I just want to understand, as a matter of practice, where she will come up short as a result of the systemic problems that you're identifying.
I mean, there's obviously the absence of any determinations. There's obviously the absence of any determination or declaration of discrimination in respect of those findings. Would be one answer. Second, I rather suspect that Mr. and Messrs. Cooper and Chegwin would be surprised if claims of indirect discrimination and victimisation could be brought by the back door on remedy. And so, paragraph 77 leaves the position as one of uncertainty. I would also say, as a matter of principle, that what the EAT had to determine, as the tribunal understood, is not a case solely confined to individual circumstance, but one of the wholesale exclusion of the tribunal's jurisdiction at all. Now, this didn't happen in this case, but it certainly could, and it was a live prospect. If an individual resigns or voluntarily discharges as a consequence of the service complaints procedure, I rather suspect that the MOD would say, well, you can't rely upon the handling of the service complaint as a freestanding contravention. And given the legitimacy of avoiding collateral challenges to that process, you can't get through the back door what you can in the front by way of remedy or recommendations. So my Lord has the primary point that I make, which is the paragraph 77 leaves justification at sea, in the sense that it opens the door to the very challenges which are said to cross the Rubicon.
Could I, since I've interrupted you, could I just ask, how many complaints, how many claims are there in the ET at the moment?
2.
Right, because
So
there was one before the one with which we're concerned. Could you just, for good order, remind us of what the substance of each of those 2 claims is?
So there's the complaint about, you have it there, let me just dig it up in case you need to see it, or at least by way of a reference. You have the claim at tab 14 of the supplemental bundle, pages 184 onwards, which is essentially a claim about the underlying matters which led to the...
Sorry, I haven't got this one numbered. It's page...
page 184,
Thank you.
My Lord, and the rider to the claim, pages 199 onwards.
So this is 6th of May 2020.
Yes.
And without spending too much time on the actual paperwork, what's the gist of that complaint, that claim?
Bullying, marginalisation, exclusion from opportunities, negative performance appraisal, damaging career prospects, lack of support during IVF treatment, in a nutshell. In other words, the claims which then made their way to the service complaints procedure, because it was accepted that the service complaint was itself a protected act advancing allegations of discrimination.
Right.
So my Lord is right. She has the ability to pursue that claim.
Sorry, say again.
My Lord is right. She has the ability to pursue that claim unfettered by the strictures of Section 121.
Right, and what's happened to that at the moment?
Stayed, pending these matters.
Right, and then in July the 9th, 2021, she issued the second claim.
Yes.
And again, just in a nutshell, that was
Victimisation and indirect discrimination.
in relation to...
Sex, as to indirect discrimination, practice being the absence of oral hearings, victimisation being...
Right, so without trivialising it, she has quite a lot of complaints already in the ET,
Yes,
which are yet to be determined.
yes, that's right.
But what is she excluded from pursuing?
Excluded from pursuing the indirect discrimination claim as regards the practices adopted during service complaints procedures, and the victimisation claim, namely that the reason why the complaints were dismissed was because they were complaints of discrimination.
It might be said that this is the sort of further complaint that the statutory mechanism was set up to control. Where one considers everything that is already before the ET.
Well, certainly one can understand why the decision bodies and appeal bodies would not wish to entertain service complaints about those matters. But there's no reason, I think you have my primary submission, there is no reason why the tribunal's jurisdiction should be ousted over those matters. Just the same way as it isn't in respect of any other acts that may take place in the confines of a grievance process, which may be consequential in effect, and often are, that they are the final straw which leads someone to head for the exit door. In short, we say that there's no legitimate aim rationally connected to the discrimination at all. And what one is left with when stripped to the essentials is a circular proposition that the aim for denying or interfering with the enjoyment of Article 6 rights is to deny access to the court. As to paragraph 55 of Mellon and Friends submissions, the absence of the aim to avoid collateral challenges, that aim is at best incoherent given the avenues that are not excluded. As the tribunal rightly noted and concluded, there were less intrusive means to achieve the same aim, namely to preserve the bar on service complaints as intended by the 2015 regulations, but to present no bar on access to the Employment Tribunal. Indeed, that was entirely in keeping with the changes to the Equality Act, which prize a gap between...
Just a minute, slow down.
Sure.
Sorry, that was the position before the 2010 Act.
Well, the point that I was developing is that the less intrusive means, namely finality within the service complaints procedure, but not ousting the jurisdiction of the tribunal, is in keeping with the changes in the 2010 Act that prize a gap between the service complaints procedure and the process and jurisdiction of the Employment Tribunal.
Probably being slow, Mr. Milson, because you just sort of explain what you mean by that, please.
Well, what I mean, my lady, is this. If one goes back to the original position of the RRA Act as opposed to matter, wait for a determination of the Defence Council, the change in the 2010 legislation
Oh, I see, the change.
prizes a gap, and we say that the less intrusive means identified by the tribunal, finality in the SC process but not ousting the tribunal, is entirely in keeping with those changes.
There has to be some rule about finality in the service complaints procedure. Otherwise, it's an endless pack of Russian dolls. You make the service complaint. You say that's very unsatisfactory, so I'm bringing another one, and then you say the second one's unsatisfactory, and so on.
Yes, and the claimant presents no issue with that at all. Such was. This is the slight irony of all of this. Faith in the RAF was at a pretty low ebb before this procedure. It's certainly lower now. The claimant has no desire whatsoever to go through the carousel of service complaint after service complaint. She seeks determination of claims before an independent and public tribunal.
Any indication of when the claims that are not affected by this appeal are going to be determined?
Next year, I believe, end of next year is the listed date.
And a hearing lasting how long?
9 days, I believe.
So, in a sense, when you say she seeks to have these matters dealt with in a public tribunal,
Yes,
there is going to be a public tribunal in relation to the substance of the treatment that she complains about.
I think that listing is to take allowance of the possibility of this claim. Of the
Well, yes,
tribunal.
but this claim is only going to be one further chapter in the complaints that she wishes to make.
It's a consolidated listing for all matters,
Yes.
erring on the side of caution,
Yeah.
which is that the tribunal will have jurisdiction over both complaints. I think the central point I'd make in response to some of the questions from my Lord Justice Jackson is this: the focus is upon justifying the discrimination rather than seeking consolation in that which the claimant can do, in my submission. Particularly where the determination of complaints in the armed, as to discrimination in the armed forces, is a public good in my submission, not simply for the individual litigant, but for the ensuring that there is accountability at large. Access to court for the court for the determination of those complaints is an important right for the individual and in the public interest. And whilst the status stricto sensu is service member or service personnel and thus not a core status, it is one closely intertwined with one which is, namely sex. To the extent that the aim scrapes through the legitimacy and rational connection thresholds, that aim is greatly outweighed by the scale of the Article 6 intrusion. And on a fresh assessment, this court is invited to conclude that the contravention is unjustified. If there is a need to establish errors in the EAT approach, 4 are identified at paragraph 67 to 76 of my submissions. Head notes only. First, the EAT impermissibly narrowed the measure which fell to be justified, which was not finality in the internal process of one individual, but the wholesale exemption of the right to pursue contraventions in the handling of service complaints, irrespective of who experiences them. Second, the EAT impermissibly relied upon the adequacy of alternative remedies, where the real question for Article 14 purposes is whether the differentiation can be justified. Third, the EAT...
Again, Mr. Milsom, not for the first time. If this is written down, give us the paragraph numbers.
Yes.
If it's not, you'll have to go more.
It's 67 to 76 of my submissions, my Lord. I'm conscious I've got to deal with ground 2 as well. So apologies if I'm going a little speedily. Third, that the EAT erroneously conflated finality in the service complaints process with barring access to the tribunal, an error which the ET was astute to identify and address in its assessment. And finally, the EAT failed to undertake the balanced exercise in Bank Mallet, having regard to the comparison between the legitimacy and rationality of the aims and the scale of the discrimination at large, which is why I say that the dissonance between the conclusions on equivalence and effectiveness and the conclusions on justification are so stark. If you're with me on breach of either A6 or A6 read with A14, we come to the question of compatible construction. The wording of Section 3 will be hallowed and familiar to this court. Test being possibility. Again, if I can take you to the conclusions of the tribunal at first instance. First, tab 9, page 118. Paragraph 2, of course, the tribunal identifies the issue at hand in crisp terms, namely one of jurisdiction. Then at paragraphs 31 through to 53, there is an impeccable direction on law on both justification and interpretive obligation. If I can flag in particular page 127, paragraph 50, well, it starts at page 125, paragraph 51 onwards. The tribunal undertook a careful assessment and analysis of Gaydon and Mendoza, and in particular drew reference to the observations of Lord Roger, or the conclusions of Lord Roger, at paras 123 and 124, at page 127. The fact that the tribunal or a court is not devising in a parlour game with Parliament, but must, so far as possible, make legislation operate compatibly with convention rights. This means concentrating on matters of substance rather than on matters of mere language. That led the tribunal to conclude rightly at paragraph 52. Section 3 in principle permits a court or tribunal to write even a wholly unambiguous legislative provision if the convention requires it, but only if doing so does not go against a fundamental feature of the legislation. Then if we come to the application of that test, page 130, E.T. rightly observed that it was a question of interpreting section 121 and not the 2015 regulations, where the effect of 121 be altered to permit the ET to have jurisdiction. That would do nothing to undermine the stated intent and result of the 2015 regulations, would still exclude the claimant's complaint from the SC process and provide that process with a desired finality. The only change would be to enable the claimant to bring the claimant to the complaint to the ET as an additional remedy to those the respondent concedes would otherwise still exist. It says that the revision would not fly against the grain of section 121, the underlying purpose identified there. And paragraph 69 does not risk the ET wading into the second prohibited category identified by Lord Nichols, requiring the courts to make to make decisions for which they're not equipped. And the proposed solution I've already taken you to paragraph 89, a recognition by the tribunal that drafting is not of the essence. The EAT's analysis, or conclusions, page 85, so forgive me, page 75, paragraph 85. The only passage of Gaydon which the EAT made reference to was a cautionary one. Lord Nichols is qualifier at paragraph 33 of Gaydon. And then if we go to the essence of its conclusions, paragraph 79, page 79, paras 97 and 98. The central difficulty, forgive me, before I go there, and I'll take you back to paragraph 86, page 75. In addition to only being able to adopt a meaning consistent with the fundamental feature of the legislation and only making decisions that a court's equipped to do, a third constraint on the exercise of power not relevant to this case, but mentioned for the sake of completeness, is where the interpretive obligation would give rise to important practical repercussions, which the court is not equipped to evaluate. In that respect, the claimant agrees that this is not a scenario where there are questions of practical repercussions which a court is not equipped to resolve. We then come to paras 97 and 98, page 79. Central difficulty for Mr. Milsom is that his proposed interpretation of section 121 directly contradicts the wording of the legislation by seeking to make a matter which is excluded from being made a service complaint, etc. I accept that the Equality Act was designed to give effect to EU law.
Well, just pausing, 97, the first sentence is correct, isn't it? You are saying that you are seeking to make a matter which is excluded, something which is not excluded. I appreciate you say that doesn't go against the grain of the legislation. That's a different point, but the first sentence is correct, isn't it?
Yes, it's correct in the sense that the literal effect of 121 read alongside the 2015 regulations has the effect that's conceded as a matter of literal application of the wording.
Yeah.
And whether there's a modifier to the language or not, I'm prepared to take that on the chin, as it were. Let's say there is a contradiction to the wording of the legislation. So I don't necessarily take issue with that. What I do say is that language is not the same as purpose or substance or effect, and it's that territory to which Gaydon is focused. I also make the point that this is the implications of primary statute essentially bolted on by way of subordinate legislation, which has some bearing on the approach to the interpretive obligation under Section 3.
But is that, I'm just wondering, I'm just thinking aloud, I mean, is that sentence right if one looks at section 121 of the 2020 Act and the definition of service complaint in section, whatever it is, 1418? Because, I mean, at first sight, it doesn't seem to me clear that the draftsman of the 2010 Act was necessarily intending to entail every feature of the service complaints scheme.
Well, I think that may well be right. Let me spell out what I hope is clear from the claimant's submissions or written submissions. The purpose, as opposed to the wording of section 121, is to afford an opportunity to remedy a service complaint. And it's an opportunity only. The tribunal is in no sense bound by what use is made of that opportunity, but the opportunity has to be afforded. The effect of the 2015 regulations is that by way of subordinate legislation, the Secretary of State has decided that opportunity is not desired or welcome when it comes to complaints about service complaints. But if the claimant has done all that she is required to do, it's not a fundamental feature of the legislation to debar jurisdiction over Equality Act claims. In other words,
isn't your complaint really about the regulation?
It's
everybody's been re-amending the statute, but isn't it really the regulation that is objectionable?
Well, it's the application. Yes, I mean it's the implications of the regulations on the application of Section 121 that is the issue. But if the fundamental feature of Section 121, which is, as the tribunal observed, what it was really trying to interpret and apply, the statute over which the tribunal has jurisdiction. The tribunal doesn't have jurisdiction over the 2015 regs at large. It was applying Section 121. Fundamental feature is to afford the opportunity to make the service complaint where that opportunity has been extended by way of the service complaints regime. But where, by way of the 2015 regulations, the Secretary of State has decided that this is not an opportunity it seeks. It's not a fundamental feature of the legislation to set impossible to achieve bars on access to the tribunal.
But my question really is are the 2015 regulations a fundamental feature of the 2010 Act?
No.
Because they're made under different powers and they concern something different. They
Yes.
have, as it were, a sidewind effect on Section 121, even to the extent that they bar particular kinds of things from being service complaints. But what I'm struggling with is how the 2015 regs are a fundamental feature of the 2010 Act.
In my submission, my lady, they're not. The fundamental framework of the Equality Act was to treat service personnel as in deemed employment, conferring jurisdiction under Part 5 for the determination of their Equality Act complaints, subject only to the requirement that the service personnel do that which the parallel regime requires, no more, no less, which is to present the service complaint.
Yes, and there's no in principle objection to that.
This appeal does
So
not.
which is why I think we're on the same point. Which is why we're not. It seems strange that the battleground was the Act rather than the regulations. Because if the regulations hadn't said what they said, then you wouldn't have the complaint that you bring here.
Well, the complaint wouldn't arise if the tribunal's approach, and we say it is correct, which is to say it's not a fundamental feature of the legislation to require people to do things they can't do in order to give the tribunal jurisdiction.
But that the problem arises in the regs, not the Act.
Well, it's the problem of how to interpret the Act in light of the regulations, with the firm and important point to be made that for subordinate legislation or regulation to prevail over primary legislation is the tail wagging the dog. Just finally on the EAT conclusions, I accept that the Equality Act was designed to give effect to EU law, but whereas here it sought to read down the exact opposite of the literal meaning of the words, it's not possible to do so. The central point is this. The tribunal correctly understood that the reach of Section 3 is broad and requires a focus upon legislative purpose rather than language, and its application of Gaydon was right. In the interest of time, I'll take, if I may, fairly briefly to passages of Gaydon.
Well, now, just a minute. How much ground have you still got to cover?
I'm on 20 pages of 25. Well, I've discussed timetabling with my then friend. The aim was for me to finish at lunchtime.
Yes,
and that's
good.
what I'm on track to.
Okay, right. And Gaydon Mendoza is pretty well known.
It is, and I don't propose to spend too long on it. All I would say is that with respect to the EAT, its focus was upon the qualifier of paragraph 33 of Lord Nichols's judgment, rather than the thrust of that decision. And its focus upon language rather than purpose, paragraphs 97 and 98, respectfully suggest that the true ratio of Gaydon was not fully seized by the EAT. Context of Gaydon is well known. Survivor rights to a spouse under Para 2, Schedule 1 of the Rent Act in circumstances where everybody agreed that Parliament, when enacting the 77 Rent Act, did not intend those rights to be extended to same-sex couples. That was the elephant in the room that in places is spoken. What's clear from Gaydon is that language, even unambiguous language, is not the determinative feature. And in view of the familiarity of this court to it, can I just give you paragraph numbers and ask you to read them in due course? Lord Nichols at 29 to 30 and 32. Lord Stane, recognising that the declaration of incompatibility is the measure of last resort, and that in almost all cases a convention-compatible construction can be reached. See paras 40, 50 and 46 as well. And I will take you to this if I may. Paragraph 40, page 562. Lord Stane. Two factors are contributing to a misunderstanding of the remedial scheme of the 98 Act. First, there's the constant refrain that, if just you're reading down or reading in under Section 3, would flout the will of Parliament expressed in the statute under examination. But this question cannot sensibly be considered without giving full weight to the countervailing will of Parliament as expressed in the 92 Act. The passages which found some favourable by the ET, with the ET from Lord Roger, paras 122 to 123 are important. But a considerable departure from the actual words is licensed because one looks to effect rather than form. Likewise, Baroness Hale's conclusions.
I'm so sorry, it's my fault. Which paragraph of law?
122 to 123.
122 to 123, thank you. Sorry, it's my fault.
And final refrain of Baroness Hale, page 598. Notwithstanding the fact that this was a case in which everybody agreed this intention was not within the scope of the wording and not intended by Parliament where enacting, Baroness Hale says this is not even a marginal case, well within the bounds of what's possible under Section 3 of the HRA.
If it was the intention, if it was the intention of Parliament to answer the question, should start again. The question here is whether the ET has jurisdiction over the manner in which a service complaint is dealt with. And it's not obvious, at least to me, what Parliament's answer to that question would have been.
You have my submission,
Yes.
which is that one can well understand why this is the secondary problem we have. It's not a question of Parliament; it's subordinate legislation, which has never been debated or discussed or determined by Parliament.
Yeah, that's quite right.
So, what did I believe the Under Secretary of State have in mind by way of these subordinate legislation to avoid the endless carousel of service complaints?
Yes.
No issue with that.
But also the subordinate legislation is made under powers conferred by the 2006 Act.
Yes.
And it's directed at the service complaints regime.
Exactly.
It doesn't have an explicit purpose to affect the jurisdiction of the ET, so
Quite
it only
so.
does so by assignment, in effect.
In circumstances where there's nothing to suggest that that sidewind was recognised, seized upon, intended. Well, lady's quite right. And what's perfectly plain is that there are all sorts of scenarios in which the unambiguous wording of the legislation, of primary legislation, is amended in accordance with convention to achieve convention compatibility. Obvious example, Gillam. Gateway, requirement of a contract. Answer, you don't need a contract. Jessamy and Rostock, not a contravention of this sanction for post-employment victimisation. The only place in which one would expect to see post-employment victimisation in section 108, still on the statute books, still unamended, and yet this court decided that what those words naturally say can't have been what Parliament meant. And in view of timing, can I just flag, and it will be flagging, 5 key features which should have caused the EAT to exercise even greater caution before deciding the limits of Section 3 had been reached. In addition, if I might say, to the obvious one that my Lord has just observed, which is that it's not clear, it's not, but by no means unambiguous that Parliament intended to do that which it's done by way of a side with. First, the consistent recognition in the authority from the highest court that the tribunal is the arbiter of discrimination claims in work. Michalak P. Unison Eklund. Second, the Equality Act was intended to give effect to EU obligations and general principles of EU law, including effectiveness and equivalence. And even after EU withdrawal, that's a relevant feature of domestic construction, part of the framework in which statutes should be construed. To state the obvious, the EAT upheld the ET's conclusions that the current regime offends effectiveness and equivalence. There is no challenge to those conclusions. Can it seriously be that preserving that state of affairs is a fundamental feature of Section 121? Third, the presumption against absurdity, cited in our submissions relying upon Bennion, and 2 particular features of that presumption: that litigants are not required to do that which it's impossible to do. See Bennion tab 65, 13.1 and 13.2, pages 1925 and 1929. And second, that arbitrary temporal guillotines amount to effects turning on immaterial distinctions. See page 1933.
Sorry, say that again.
Yeah. Let me rephrase it. One other feature of the presumption against absurdity is that effects should not be altered. The effects of legislation should not be altered by reference to immaterial distinctions. Page 1933. And what we have here is the inverse scenario of the post-employment victimisation cases. That you're better protected if the contravention takes place after service has ended. And if I may just briefly take you to Jessamy, tab 40, bundle 2. The legislation in issue remains on the statute books. Paragraph 19, page 929. this was section 108 is the section that deals with contraventions after the relationship, the employment relationship has ended. To spell out the obvious, tribunals are creatures of statute. They can only do that which Parliament has conferred. Section 108 was the place dealing with post-employment contraventions. Section 108(7), conduct is not a contravention of this section insofar as it also amounts to victimisation of B by A. Nowhere else is post-employment victimisation dealt with in the Act. Tried as this court could to discern any meaning to those words, it couldn't. The court was informed by the prior authority on differential protection between during or post-employment victimisation. See paragraph 30, page 932. In reference to Rees-Harper, no rational basis for withdrawing the statutory provision of protection against discrimination, including victimisation, arising out of the employment relationship as at the moment at which the employment terminates. Lord Nichols of Birkenhead at paras 37 to 40 said that such a state of affairs would be arbitrary and capricious and cannot have been intended by Parliament, a view with which I respectfully agree. The draftsman will of course have been aware, Parliament must be taken to be well aware of that history. What happened in Jessamy, I can say this from some personal experience, is that the EAT reached the conclusion that plainly authority was against the natural wording, the natural effect of those words, but the interpretive obligation could not go so far as to remedy those unambiguous provisions. The issue was then came before this court, page 936. And if I could ask my lady, my lords, to read paragraphs 43 and 44.
Well, this court held that the anomaly was so egregious that it must have been a drafting error. Inco Europe and first choice distribution. Are you saying that this must have been a drafting error?
What I say, my lord, is that if you're with me on contravention, if you're with me on contravention, the secondary question is how far does the interpretive obligation go?
Yeah.
And in my submission, what has happened here is exactly what happened in Jessamy and Rostock, which is that the EAT has failed to, in words of Lord Justice Underhill, given the judgment of the court, failed to appreciate the extent of the flexible interpretive obligation explained in Gade.
So did this court apply the Gaydan report? Because I haven't read the
Yes, it did.
decision. It did.
Yes, it did. So it reached the same course through both domestic and...
So it was satisfied, INCO, that it was a drafting error, but it also reached the same result via section 3.
Marleasing, and agreed between the parties that the approach to section 3 is coextensive with that of Marleasing.
Oh, I see.
So agreed between the parties in this appeal that there's no difference in approach between Marleasing and section 3. So the critical point of Jessamy is that having found that there was a contravention there of EU law, but whether one gets there by way of convention or EU law matters not, because the interpretive obligation is the same. EAT and Jessamy had failed to recognise the full sweep of the full scope of Section 3, even though the natural reading is entirely contrary to the outcome that the court had reached by invoking malleasing. That's my point 3 of 5. I can deal with
Yes,
the other two pretty
keep
quickly.
going.
4. This is not a scenario in which Parliament has made a decision to oust the tribunal's jurisdiction. We agree with SCOAF and indeed the ET. This may well have been inadvertent, and in any event, it's not by way of primary legislation. That deals with that leads to point 5, that the scope of the court's obligations under sections 3 and 6 as regards subordinate legislation extend to the right to disapply it altogether. And you see you have RR, I hope, which was sent through yesterday, or if not before. The exclusion here arises solely as a consequence of subordinate legislation, as has been accepted by the respondent in pleadings. See Paris 26, I'll take you there briefly, 26, page 259, I believe. That's forgive me. Paragraph 16, page 145.
Of the core bundle.
Of the core bundle.
Yeah.
The respondent recognises that it's the effect of the regulations rather than the Act to remove the jurisdiction of the Employment Tribunal. Now, distilling those points all together, we simply say the tribunal was right to conclude that a convention-compatible construction was possible. The EAT focused impermissibly on language rather than purpose. It was not a fundamental feature of the Equality Act at large, or Section 121 in particular, to deny access to the tribunal where the armed forces have had the opportunity to remedy the service complaint to the extent that that opportunity, the right to exercise that opportunity, has been exercised by the complainant. And indeed, it's difficult to see in practice why this is any different to the construction proposed by the respondent in Duncan. The whole point of the MAD's position in Duncan was to say, Miss Duncan has done all that which she has to do. Having done it, it would be a breach of Article 6 to deny the jurisdiction of the tribunal. How is that any different in principle, simply because the issue arises by way of subordinate legislation?
And the passage you took us to showed that it was quite a sort of broad interpretation of
Indeed.
Section 121 that was proposed, as you say, by the
In
respondent.
recognition of the fact that the drafting is not of the essence.
Yeah.
It can in no sense be a fundamental feature of the legislation to engineer a scenario in which former personnel have the access to service complaints, SCOAF, judicial review and the tribunal, but actively serving personnel are deprived of access to the ET. My learned friends are respectfully wrong to say that there's a whole range of options open to the Secretary of State or to anybody else, essentially for the reasons identified by SCOAF at paragraph 27 of their submissions. Those options are pretty limited. Subordinate regulations say we're not interested in service complaints about service complaints. So the notion that there was nonetheless a residual expectation or role for those service complaints or referrals to SCOAF about the issue, etc., is, in my submission, misconceived. Parliament has at no stage, nor has the Secretary of State, suggested that a complainant must make use of SCARF. And so there's no real options other than confer jurisdiction on the ET or deny it. And it's neither a fundamental feature of the legislation nor a question of immense practical sensitivity to determine that binary question. On balance and on reflection, we say that the simplest proposal, mooted by Employment Judge Laing, at paragraph 89 of that judgment I took you to earlier, is the best. Although you have my point that the drafting is not of the essence. But the benefit of that, adding 121 to 1211A, where the complainant is entitled to do so, is that it's entirely in keeping with that proposed by the MOD in Duncan, and the essential purpose of Section 121. Give an opportunity to the extent that you have a right to pursue that opportunity. And once you've done that, you've done all that's required. If you're not with me on ground, I think originally ground 2, but now ground 1 or vice versa, the interpretive obligation, we say declaration of incompatibility. But we are far beyond the outer, or far within the outer limits of Section 3. The tribunal was right to accept jurisdiction over these claims. The EAT was wrong to deny it, and we ask that the tribunal's order be restored.
Thank you, Mr.
Can I just
Milson.
turn my back to check?
Yes, of course.
Nothing further. Thank you.
Right.
Bit of a counter at the end, but I hope we got there.
Thank you. The clock in this court is pretty slow. It's 10 past 1 by my watch.
Apologies for truncating
5 past 1 by. We'll resume in an hour, which is 5 past 2 by that clock and 10 past 2 by anybody else's.
Court rise is able.